This is from the studios of Radio Al-Ansar.
Assalamu alaikum wa rahmatullahi wa barakatuh. This is Fawzia Peer from Minara Chamber of Commerce. And this program is from Minara Business Matters. Our topic tonight is on workplace harassment. It's a very important topic, and I hope and pray that all of you sit back, relax, and listen to this important topic. You know for a fact that workplace harassment can include physical, verbal, sexual, and emotional harassments. It's not just women who are impacted by workplace harassment. Anyone can be a victim these days. If you think you have been experiencing workplace harassment, make sure that you contact your human resource department as soon as possible to protect yourself. This evening's discussion is for employees as well as employers who feel that they or a colleague may be experiencing workplace harassment, as well as business leaders who want to ensure the employees' safety within the work environment. Workplace harassment exists throughout all types of workplaces, from bullying to outright discrimination. It's important to understand workplace harassment so you can avoid a hostile work environment in your small business. So while the most basic types of harassments are verbal and psychological, there are more serious forms such as physical and sexual. All types of workplace harassments are illegal. They not only affect an employee's productivity or the comfort and safety at work, but they can also expose an organization to legal liability if it does not handle harassment properly. So tonight, we have this young gentleman called Linden Bowers. He's a labor lawyer. So Linden, the labor lawyer, delivers top-tier legal counsel and training of employees to a broad array of public and private companies, private equity firms and financial institutions, government entities, and other institutions and individuals. So Linden's legal company represents clients in areas such as corporate governance, business and contract law, company law, public procurement, labor and employment, amongst others. So Linden delivers results by focusing on the unique needs of each business client, bringing to bear their commercial litigation experience and corporate planning expertise. So welcome, Linden. Welcome to Al-Ansar radio station this evening. And, this program is hosted by Minara Business Matters. So I see your topic is most relevant to society these days. And thank you for coming over.
Good evening, Fawzia. Thank you so much for this opportunity, and to the Minara Chamber as well. And yes, it is a very contentious issue, to be honest. As I mentioned just before we had stepped in here this evening, it's quite a sensitive topic, but from the outset, I must say there are two schools of thought, and this is what I've discovered from clients of mine. On the one hand, we have the school of thought who fully supports this new code, where, harassment has for far too long been either overlooked or not been given the serious attention it needs or deserves. And on the other hand, the school of thought is that, have we gone a bit too far? What is now harassment? And it's sort of so general now that even, for example, eye rolling or something that may not seem as serious can be construed as a form of harassment in the workplace. So we'll unpack that as we discuss this. Yeah.
So what I would like you to actually, discuss tonight is that tell us a little bit more about, workplace harassment in South Africa. And what does that include? Because, I mean, I don't think society has taken this that serious, as you alluded to the fact now. So tell us, unpack that a little bit, the workplace harassment in South Africa.
Of course. So first and foremost, the aim and the thinking behind this code is to protect the most vulnerable employees in the workplace who are often sadly prone to forms of harassment, either based on their earnings or their status within the company or society. But the term harassment, as per the code, it manifests in various forms. So the most common and obvious ones which we know of are physical forms of harassment and the various serious form of sexual harassment, which, by the way, this code has since repealed the previous code pertaining to sexual harassment in the workplace. It now covers this specifically. But quite importantly, there are emotional, psychological forms of harassment as well in the workplace, which many people do not realize, or perhaps they do and don't take it as seriously. And when I also speak about vulnerable groups of employees, I also speak about those perhaps that are commonly ostracized, so perhaps same-sex employees or employees belonging to the LGBTQIA community, employees belonging to a specific culture or religion, females. So where there's already a disparity between roles or status in the workplace. But when we speak about harassment, Fauzi, we also speak about, if I could define it, as something or conduct that is unwanted, number one, but also unwelcomed. And we speak about two persons or two parties. So the unwanted, unwelcome conduct is normally committed by the perpetrator, we call it. And the receiver, sadly, of this unwanted, unwelcome conduct would be the complainant, which we refer to in the workplace context. And then importantly, it must show somehow, somewhere, that such conduct had the ability or propensity to impact or impair that person's dignity. And often it's calculated or intentional, yes. And importantly, it can also be indirect, not just direct conduct. And as I've mentioned, it doesn't have to be physical, but also emotional. Quite interestingly enough, it doesn't need to only be persistent conduct. It could also be a once-off or an isolated incident as well. So there are very clear examples which I will discuss as we go along as well, Fawzia.
You just spoke about verbal harassment. What constitutes verbal harassment? Give me some example.
Of course. So I've had to chair some matters of this nature, truthfully. So the employee would say, no, my manager, for example, has harassed me for the past few years. And then you ask the employee to speak of the actual incidents. And it could be in the form of bullying, perhaps, a form of intentional discouragement of some sort, criticism, but unhealthy criticism, of course. Harassment also in the form of text messages. So even after hours, the employer may, for example, belittle the employee, call them unkind words, things like that. So there's obviously a scale or degree where it's abusive language, but also it can be persistent language which could affect the employee's dignity.
Yeah. So that, one never ever thought that verbal words could be in harassment. Like, it can be, I would say, an ongoing battle of destruction that threatens your health and career. If your employer keeps saying demeaning words or offensive gestures to you and unreasonable criticisms, that can really affect a person, I would say. When it comes to verbal harassment, it can involve insults, I think, and slurs. Oh, God, it can be, even unwarranted jokes, I think.
Correct.
Yeah.
Correct.
I'm just trying to think of even hurtful comments, even when such behavior can have, all this can have a very negative psychological impact on the victim.
Correct.
I think it brings about depression. What would you say psychological harassment is about? How would you explain that?
So, obviously, I'm not a psychologist, but psychological forms of harassment can often manifest itself in and I use the example again, I say a manager who has an employee reporting to him or her would purposefully comment on, let's just say, an employee's appearance, body shaming, whatever that may be. And psychologically, it affects the employee in terms of their confidence and their ability to conduct their work. And there's been cases where, the employee may result in the employee having to go on medication or seek professional help, or worst case scenario, even suicide. So the code is there for a reason. It's there to protect those vulnerable employees and to show employers or the workplace that these forms of harassment, even psychological forms of harassment, will not be tolerated. And as per the code, it's termed the elimination and the prevention of harassment in the workplace.
So in a way, psychological harassment is similar to verbal harassment, I would say.
Correct.
But it is, I suppose, it is more covert and consists of this, certain type of tactics that they use, like withholding information, of
Correct.
the employee. So these actions are intended to actually mentally break down the victim, I think. While listening to you, I think that is what it is. To mentally break down the victim, chip away their self-esteem as well.
Correct.
And undermine them at work as well.
Correct. I mean, Fauzia, I've assisted both sides, the employer and the employee, and the workplace is a space for professionalism and ethics, yes, but truthfully, people spend most of their time at work, and if there's a toxic work environment, the code is there to protect. And remember, it's not just applicable to employers, and the duties are only, for the employers to adhere to, but also co-workers, employees.
Yes.
Quite interestingly, Fauzia, slander you've mentioned and withholding information, but instances of sabotage as well.
Absolutely, yeah.
It's so broad, which is a positive actually. So, one cannot just, there's no hard or fast rule in terms of applying the code itself.
Tell me, do they have this digital harassment? Does that take place, like cyberbullying or something?
Definitely. So there are instances, and I've had an instance where an employee was bullied and harassed actually in terms of social media, but workplace, it's often a platform for emails to be exchanged.
So it's a newest form of harassment.
Correct.
Yes.
Correct. So not your
and it's, I think it occurs across many outlets.
Correct.
Yeah, social media, creating a fake persona
correct.
to bully someone online. We see that all the time.
Correct.
And creating a web page about the victim to mock and belittle them.
100%.
God, it's always around and making false allegations.
False. And just on that point, I had a very specific case where the supervisor would send emails to a client, copy in the employee, and in that email would belittle the employee or criticize the employee, undermine the employee. So now it's before a third party such as the client, and the employee obviously felt aggrieved and harassed by that. So
absolutely,
yeah,
social media has become common in the workplace. See,
very, very common.
And I think what normally people should do is to monitor the situation. That's the only way they can, and taking screenshots of what is written for legality when it comes to the legal issue on your side.
Correct.
Because you need proof,
Proof.
You have to save the emails, I suppose, on your personal computers and keep a file of everything. What about physical harassment?
So physical harassment has always been dealt with in terms of our jurisprudence and the labor law, case law. They're quite stern in terms of, so let's think of very common forms, okay? So where an employee is physically bullied in the workplace, it's a form of harassment, physical, where the employee sadly is subject to a form of sexual harassment, okay? Now the sexual harassment is a whole big sphere, and various forms of sexual harassment can.
Yeah, that's another cup of tea.
Another cup of tea.
Yeah.
But again, the physical aspects or form of harassment can fall under that umbrella, because sexual assault, inappropriate touching, etc. So the code is quite clear on that. There are levels and degrees of harassment, yes, and I would definitely advise and say that physical forms of harassment would be at the top level in terms of a serious form of harassment in the workplace. I mean, there's no reason to be physically touching or assaulting another co-employee in the workplace, especially if it's unwelcomed and unwanted.
Yeah, it can vary, in degrees. Like, for instance, simple unwanted gestures like touching your hair and, the employee's hair, or possibly the face or the skin.
Yes.
All that is severe gestures, I would say. Now, in this day and age, one would call it physical harassment.
You would think COVID would have maybe asked people to restrain themselves a bit more, but it does happen. There was another company where there was an ethos where the employer would hug employees every morning, until one employee just felt completely uncomfortable with it as a female, and he thought it was completely normal. But the code again, there's an element where it says, well, to what extent can employers or employees, connect? But yes, if it's unwanted again and unwelcomed, then it can be deemed as a form of harassment.
I see you kept on bringing this thing about code, So there's an amended code of good practice on prevention and elimination of harassment in the workplace. So if it is now amended, tell us more about the code of good practice. What is it?
So just to give some context, South Africa is a party to and had ratified what we call the International Labour Organization Convention 190, which dealt with the elimination of violence and harassment in the world of work. And that's the global term. We call it the workplace. It's referred to as the world of work. And because South Africa had ratified this agreement, we were then obliged to implement the terms of such agreement internationally, yes, but also domestically. And when I speak about the code, the actual title of the code is the Code of Good Practice on the Prevention and Elimination of Harassment in the Workplace. It's quite a mouthful, which had been signed by our Minister of Labour in March this year. And what the code does, Fauzia, is it now codifies all forms of harassment, what it means, who it applies to, and obviously specific practical measures now for employers and employees to adhere to. But quite interestingly, it also replaces the previous code of good practice we had on sexual harassment we've had for many years. But I would say that it replaces it in a good way. The previous code was quite specific in terms of sexual harassment. And I think now the world has realized that sexual harassment isn't the only form of harassment. There's so many varied forms of harassment in the workplace, as we've already discussed. So when I speak about the code, that's what it is. And I would encourage employers and employees to download it. It's easily accessible on the internet, on a government website, to download and have a copy. It's 32 pages long for midnight reading. So, yeah.
You think the employers are going to read that, or labor consultants? Yeah. So what you're saying is that the reach of the code is now much wider.
Correct.
Much wider in order to deal with increasingly diverse workplace. Yeah.
Correct.
So, in another way, if I can put it this way, that the test for harassment now takes into account whether it was unwanted.
Correct.
The nature thereof and the impact of the victim.
Correct.
So it's no longer acceptable just to say, I did not mean it.
100%. You hit the nail on the head, Fauzia, because the common, I won't say defense, but response by the perpetrator is, well, it wasn't my intention, I didn't mean it, or it was just in jest, or whatever the case may be. And that's not the test. It's not enough. Intention isn't sufficient. So objectively, you have to look at it, yes, but the complainant must also demonstrate and show, or the person looking at the matter must see whether it had the impact or the ability to impact on the complainant's dignity, but also have a look and see whether or not this would be, condoned in any other context, whatever the perpetrator's intention or thoughts were.
When I listen to you, I just think now that the new code is better now. It encourages employers to adopt a zero tolerance attitude towards harassment in workplace, which is good. It places more responsibility on the employers now to educate the employees about what harassment is.
Yes.
Which is good, which is fantastic, because employers who fail to take adequate steps and to eliminate harassment within a reasonable time, and they I think will render themselves liable for damages, even if the harassment consists of a single incident. So Linden, we just we covered the fact on code of good practice, and you enlightened us quite efficiently on what should be done and what are the new employees code now that they have to follow. So I read a recent High Court judgment where they found the employer and the harasser jointly and severally liable to pay the plaintiff 4 million rand in damages for their failure to adequately deal with a case of sexual harassment in the workplace. So that shows that if it's not done well, the case, and if the employees are not taking it seriously, you are liable to pay a hell of a lot of damages. So employers should develop clear procedures. Very important that they develop clear procedures to deal with harassment, which enables the resolution of problems in a gender-sensitive, confidential, efficient, and effective manner. So when an employee has reported an alleged incident of harassment or laid a complaint, the employer is obliged, and he's obliged to investigate the allegation of harassment, and I'm sure you agree with me, and advise the complainant of the procedures available to deal with the harassment. So in actual fact, if the employee is not happy with what human resource is now taking into consideration of the allegations, they can then come to a labor lawyer like you.
Correct.
So those procedures should be outlined to them.
Yes. So, Fawzia, I can't emphasize how important it is that companies, especially the larger companies where they have a high number of employees, there needs to be a workplace policy which deals effectively with harassment. In fact, the new code under Section 9 actually makes provision for that under harassment policies, where it provides that the employers should either include it in terms of the existing contracts of employment, or sometimes the employer may be subject to an existing collective agreement. There should be a policy dealing with harassment in the workplace, which would deal with what we've spoken about already thus far. But as you've touched on as well, the code or the policy in the workplace should also outline what mechanisms are available to complainants in terms of educating them, number one, but also educating them in terms of what they can do should they feel aggrieved by some form of harassment in the workplace. You're quite correct.
So in a way, you're trying to say that contracts are not only negotiations and agreements reached between the employees and employee. There should be arrangements that are essential tools in managing the positive and constructive relationship between the two parties.
Yes.
That's very important.
It's very.
And therefore advise them how to deal with it professionally.
Correct. So, you've touched on it already, Fauzia. The mechanism, there should be a platform first and foremost for employees to feel comfortable enough to approach HR, for example. But sometimes the employees don't want to be identified. And, our South African law does protect what we call whistleblowers, people who want to make anonymous tip-offs, for example. But the code also clearly states that confidentiality is key. Sometimes the complainants don't want to be identified. They just want the matter to be resolved. So number one, the employer should actively create the opportunity for employees to report incidents of harassment. But secondly, the employer should also protect the complainants once they've made a report, whether they are identified or anonymous. Because as in that judgment, the employer can be held jointly and severally liable with the actual perpetrator, for example, should there be damages sought after by the complainant or complainants.
Linden, I'll just take you back a bit. You spoke about the code of good practice earlier on, right? Now, is this just a South African domestic concern, or is it international as well?
No, it is international. So, as it indicates, we are a part, or rather we have ratified the International Labour Organization or Convention, which is specifically dealing with the elimination of violence and harassment in the world of work. And that term world of work, Fauzia, it's quite interesting because people may think of it and think, well, world of work, the workplace, maybe perhaps an office environment, a construction site, and it's not so restrictive. It actually applies to prospective employees, so people seeking work, certain areas of the workplace which are not common areas, so it could be restrooms where harassment could take place. Perhaps when you're engaging with the client, for example, it's so broad that harassment can be deemed as even having occurred where you are engaging with a colleague outside of working hours where you're feeling harassed. So again, it's not just a domestic concern, it's an international concern. There's been a rise in workplace harassment. So yes, that's why the world of work has now become, it's come to this where we have to reduce it to a code where we have to implement it quite strictly.
So did you alert us to, like, for instance, who does it apply to, the code?
I'm glad you asked. So obviously the general understanding is that it would apply to employers, so in other words, managers, supervisors, directors, but also the employees, so your colleagues. But quite interestingly, it also can apply or may apply to volunteers. You think of a situation where you have a student volunteering at a certain NPO, for example. They are protected by the code. Service providers to an extent. So reciprocally or conversely, where if an employee has been harassed by a service provider or independent contractor, they may also rely on the code for protection. But as I've mentioned, it's not also limited to specific office space. It can be any other common areas or a restroom where sadly lots of harassment does take place in private areas like toilets, etc. And as I've mentioned, it can also apply to job seekers, those seeking employment as well.
So what does it mean, like, for employees and employees, if you say that,
Yeah. The main message I'm trying to, illustrate this evening is that, yes, this is a new code, but it's also not something foreign to us. We are all familiar with the fact that harassment takes place on a daily basis throughout South Africa in various workplaces, whether it's an office environment or construction site, whatever that may be. For the mere fact that we live in a diverse country, but our workplaces do also comprise of different genders, different races. So, and these things do occur. But what I would advise employers and employees or all parties is to firstly familiarize themselves with the code and where possible educate themselves. And lastly, to make it a concerted effort to include the code in terms of a workplace policy into existing contracts of employment wherever that may be necessary.
And if any of the parties breach the code, what happens then?
So the code clearly outlines it, and I'll summarize it quite nicely for you. So the code does deal with what happens in the instance where either of the parties breach the code, or in other words, where there has been an occurrence of a form of harassment. Okay, the complainant should report it, yes, but the incident or of harassment should be investigated, okay, by the employer. And it does happen, Fawzia. I'm not saying that every single report will lead to a form of harassment being action being taken from that. There are instances where they're either false reports, or there may be instances where the alleged transgressor is innocent. But the code does provide that disciplinary action can be taken if the conduct has arisen, and it could lead to, for example, a form of progressive discipline. So maybe it's not a very serious form of harassment, or it may lead to a form of dismissal, depending. So, for example, sexual harassment is considered serious. It could lead to that. Now, short of that, or even where the employer does not take any form of action, okay, the aggrieved party or the complainant can refer the matter firstly to conciliation to the CCMA or to a bargaining council. That's quite important. So it's not a dead end. Complainants shouldn't feel, well, my employer didn't take my concern seriously, my employer didn't do anything, or rather the actual transgressor is still working there, he's not dismissed. They can still take the matter further to a body like the CCMA or a bargaining council. But importantly, Fawzia, is that where the actual form of harassment ticks the box of a form of discrimination or breaches now the Employment Equity Act, the Labour Court also has jurisdiction. That's also important to know as well. Or at times the Equality Court.
You know, we haven't touched on sexual harassment. As you said, it's a serious offence, and it's more common than you might think, you know. About, I would say, 35% of female respondents have experienced sexual harassment in workplace. You know, where I was in the municipality also. We always had this kind of girls coming up with this problem of sexual harassment. And it is, you know, a prevalent crime, I think. And it's not exclusive to women. Anyone can be a perpetrator or a victim of sexual harassment. So what can you tell me about that?
I agree with you there, Fawzia. It's unfortunately, you know, happens far too often. It shouldn't happen at all, you know. But sexual harassment is a very serious concern in South Africa for various reasons. And, you know, just some of the examples I can think of, it's either because for cultural reasons, but there still is that stance where if a person in a position of authority, such as a manager, may feel that they may exert some sort of power over a subordinate, we call it, or a person who reports to them, and that unfortunately leads to a form of sexual harassment. So the general way sexual harassment may occur, or the most common way, is a form of physical sexual harassment, so unwanted, unwelcomed contact, touching, sexual assault even, where the contact is of a sexual nature. But as we know, it can also transpire where there are unwanted, unwelcomed comments. So commenting on the way an employee is dressed, or the way they look, or their body, that's unwanted and also of a sexual nature. Jokes as well, sexual jokes that are unwanted, text messages, whatever they may be. But a very interesting one, and as you said, may have happened perhaps in the municipality or any industry, what we call quid pro quo sexual harassment, where, you know, certain indulgences are granted, but in exchange for sexual favors.
Yes, absolutely.
And you know, the first people may say, well, then the complainant shouldn't have found themselves in that position. But the truth of the matter is that often they are maybe in a vulnerable position, and that's what the perpetrator would focus on at that stage. So sexual harassment it's so prevalent. It's very broad as well, and the general stance is that there's a zero tolerance approach with any form of harassment, but with specific reference to sexual harassment. And I would always advise parties to take a zero tolerance approach when it comes to sexual harassment.
Why do you think that reporting workplace harassment is important? Because you'll find if a person is harassed just by a letter, and that is harassment,
yes,
or giving out information from the workplace.
Yes.
That's also, it's unethical. And many of them would say that I cannot lay this charge because I'm afraid. So that kind of fear is not good, because you're actually bringing the institution to disrepute.
Correct.
By keeping information.
Correct.
So why you think reporting a workplace harassment is important?
So it's important for various reasons. One of the key reasons is because of a lack of reporting by the complainant, the perpetrator would just continue, whether with that complainant or other complainants. Furthermore, it's important because maybe initially the initial form of harassment would be regarded objectively as relatively minor, but who's to say that it would not become worse over time, or may lead to some form of physical assault. But also importantly, it goes also down to, I won't say credibility, but if the matter has to go before a tribunal or a hearing or whatever that may be, and it comes down to evidence, it's important for the complainant to illustrate that they reported the very first incident of harassment and every single one thereafter. Not to say that if they didn't report it, it makes their case weaker or not. It's not the case. But the importance of reporting is I can't emphasize that enough, especially since our laws, in terms of what we call the Whistleblowers Act, I like to call it, does protect whistleblowers. So even if they do make a report anonymous or they identify themselves, they cannot be dismissed as a result of that. That's an automatically unfair dismissal. And they also cannot be victimized or ostracized by virtue of them making a report or anonymous tip-off. So the importance of it's extremely important, if I can put it that way.
Yeah, I think it's very, very important. The main thing is not to keep quiet.
Correct.
Because you should always report any form of harassment. And it should be handled accordingly. Remaining quiet will not make the perpetrator's behavior go away. That person is going to keep writing to you those emails, and you have to subject to that quietness.
Yes.
And so therefore all harassment incidents should be reported, no matter what.
Correct.
And all complaints should be thoroughly investigated. I also believe that, one should not retaliate, because retaliation can escalate the issue and will often make matters more complicated. Do you agree with that?
No, I agree. And there have been instances where, we're dealing with humans in the workplace, and emotions. So there have been instances where an employee may or complainant may feel harassed constantly, and then they retaliate, either physically or they, perhaps use foul language or whatever the case may be, and then they also may find themselves committing a form of misconduct. So again, it goes back to the importance of reporting, not to retaliate. Go via either your trade union representative or HR or your attorney, whoever that may be, and exercise your rights. We live in a democratic society. We are fortunate to have codes like this in South Africa, where employees and complainants shouldn't feel afraid or restricted to bring these items forward. And sadly, Fawzia, it's either they don't do so for for fear of victimization, but also they are so afraid to lose their jobs. They have this belief or understanding, well, if I ruffle some feathers, or if I make a noise and cause a scene at the workplace, I may actually lose my job. But employees are protected and complainants are protected by our legislation.
Also, I believe, and I don't know if you agree with me, that do not complain to co-workers, because your colleagues do not have much power to change anything.
Yes.
And will likely water down your version of events if they are called to testify. How do you feel about that?
So It's yes and no. And on the one hand, yes, the co-employees may not have the authority to move the matter forward, perhaps, but often employees also just want somebody to confide in, from what I've observed. But if the matter does go further, let's say to a grievance, perhaps, or even to a formal hearing, then that co-worker that you had confided in may actually be a witness, or may then stand to give credibility to your statement or version. So it does have its positives, but I agree. The better option or form of recourse is to approach HR or your reporting manager or your trade union or shop steward, whoever that may be, in terms of escalating your grievance or matter.
Yes, because you can never know how that person feels about the perpetrator and how you may be muddying the waters if you are talking negatively about them. So it's better not to complain to co-workers. Now, Linden, if you feel that, one of these employees feels that the manager, the HR manager, and also the company management did not deal with your case satisfactorily, what do you think they should do then? So
if they've exhausted all internal remedies, and by that I mean, the reporting and escalating it, asking and hopefully expecting some form of action to be taken against the perpetrator, even if it doesn't lead to that, some form of investigation at the least. If that doesn't occur, then employees have every right to approach a third party, like I've mentioned, like the CCMA or a bargaining council, where the matter may be conciliated. But because forms of maybe, say, racial harassment, as I call it, or harassment based on gender or sex, or even sexual harassment does trigger forms of discrimination, then the matter may even end up at the Labour Court, where a judge of the Labour Court can effectively deal with those specific issues, where it deals with constitutional rights as well. And again, the employer and then the perpetrator may be held liable for such conduct. So the employees are never stuck if they feel that the employer is not looking into the matter adequately. They may definitely refer the matter to a third party.
Yeah, it can be a catch-22 situation, if you want to escalate the issue to your immediate manager, unless, of course, your manager is the perpetrator.
Correct.
Then you have to bring the issue to the HR, and the HR may be very close to the manager. It can be really, it's difficult, I think. Tell me, do they have any workplace laws here? There should be some kind of harassment laws in South Africa. Do we have any?
So, although, we have the code, which is quite clear and it deals with, besides the code,
But it's used as a law, possibly.
Look, if I can describe the code, it supports existing legislation. It's a guideline as well, and even the way it's drafted, unlike perhaps a statute which is
protects the workers,
protects the workers. So it does give a lot of direction, if I can put it that way, to our existing laws. So existing laws such as the Labour Relations Act, and the main piece of legislation which it supports, or which it derives from actually, is the Employment Equity Act, which, as I said, deals with prohibition of discrimination in the workplace on the basis of whether it's race, gender, sex, sexual orientation, various grounds. So I would describe this code as more of a directive on that, and it gives guidelines specifically. But it also gives light to our amazing Constitution, namely Section 23 of the Constitution. So that answers your question.
I think we have spoken a lot about the workplace harassment. What do you finally want to say to the community out there?
So in closing, Fauzia and the community, I would encourage not just employers but employees to view this new code with an objective lens, because it's here to assist not just employees but employers, but it's also there to give light to a very sensitive issue in the workplace, but in our community at large. Harassment is a very disappointing fact that we have to face, especially coming from COVID, that people must still deal with issues of harassment. We live in a diverse society, yes, but we also live with people that have very unique circumstances. So I would encourage parties to educate themselves, learn about the code, and truthfully, if it's implemented and adhered to correctly, there should not be any workplace issues or very few workplace issues going forward.
Absolutely, Linden. And I think that further problems caused by harassment may include a violation of human rights. I think that's very important. It will certainly bring about the situation of poor morale in the targeted employee, resulting in very low production from that employee. It may also cause the employee to remain absent from work, without apparent reason or even proper authorization, and usually also causes the employee to start arriving late for work. We have found that in the municipality. So the work environment, I think, itself becomes hostile and offensive to the employee, eventually culminating in the resignation of the employee. And that is sad. We get some people either want to commit suicide as well, because they can't deal with it. So employees who are being subjected to this type of treatment should keep a careful written record of all incidents, noting down the date and time, making a careful note of what happened or what was said to them, and also noting down names of any potential witnesses. Very important. So also the employee can then confront the perpetrator, in writing maybe, and request the perpetrator to immediately cease his or her unacceptable and intolerable behavior. So employees, I hope they are listening to this. And also you said employers to you work for them. So both sides, I think it's important. And don't forget, listeners out there, that you have Linden who can offer you specialized advice and service under the many aspects of employment law. So this includes professional expert insight into and the drafting of contracts, the drafting and implementation of all relevant human resource policies and grievance procedures. So please contact him whenever you want to. You can get his number by calling me directly, and it's Fozia Peer. And I would say keep safe until next time. Thank you very much for listening in.
Radio Al Ansar Podcasts.